All rise. Judges of the court. Hear ye, hear ye, hear ye. All persons having business before this court of appeal, held in for the state of New York, may now join the air. Give their attendance, and they will be heard. All be seated.
Okay, good morning, everyone. Today, our colleague Judge Feynman is participating in oral argument remotely by telephone. Counsel, your appearance.
Good morning. My name is Matthew Hellman. I'm here with my co-counsel Sheila Tendy, and I'm appearing for David Lang. I'd like to reserve 2 minutes for rebuttal.
You may, sir.
Thank you. It may please the court. I want to focus on 3 critical legal errors in the trial below. I'll begin with the court's failure to give a curative instruction on the blood alcohol issue. Then I'll turn to the court's improper replacement of a juror mid-trial. And then finally, the prosecution's improper opinion testimony during summation.
Counsel, before you begin, before we address the adverse inference charge, if we find that the trial court violated CPL, I think it's 270-35, do we get to the instruction to the jury?
That would be sufficient by itself to require a vacatur and remand. That's correct, Your Honor. So no, you would not reach the adverse inference instruction.
Good.
I'm happy to start with that if that would be useful to Your Honor.
No, that's
because
fine.
I think that, turning to 270.35, this case will become the court's leading case on what a reasonably thorough inquiry is, which is what that provision requires. And there was no inquiry. If this inquiry was reasonably thorough, then no inquiry is not reasonably thorough. Because what happened here was, in the middle of trial, the judge summarily replaced a juror without making any inquiry as to whether or not it would be possible to have the juror change the date of the appointment that she supposedly was going to, whether it would be possible to have someone else take her child to that appointment. And what made this inquiry particularly unreasonable was that the judge seemed to believe that the juror, during voir dire, had already stated that she would need to leave trial for an appointment of this kind, when in fact the juror said exactly the opposite. So I submit to the court that if reasonably thorough is going to have any meaning, the court needs to make at least some effort to determine whether or not the juror could have postponed the appointment or had someone else go. And if you look at this court's cases and the cases in the lower courts of the state of New York, they all gravitate around that concept. This court in the Gianti case, looked at 3 different cases when it was construing this provision. And at each one, the court made some effort to reach the juror by phone, some effort to ascertain whether or not there was a way to avoid substituting the juror in the middle of the trial. In our papers, we talk about the People v. Battle case, which is really on all fours coming from the First Department, exactly the same fact pattern. The judge says that a court official told him that a juror could not attend, and the court then substituted a replacement juror in that juror's stead.
Counsel,
what the First Department said was, that is not a reasonably thorough inquiry. That is not an inquiry at all. New York law requires more to safeguard the constitutional right of the defendant to a jury of his or her choosing.
Mr. Hellman, would the lack of notice to counsel by itself be sufficient?
Well, if you look at the provision 270.35, what you'll see is it's really a double-barreled provision. It both requires a reasonably thorough inquiry by the court. That's one necessity that the provision imposes. And the second is an opportunity for counsel to comment and contribute, notice an opportunity to be heard on the issue, which is a second and independent requirement. Here we had a failure of both, and your hypothetical goes, I suppose, to if the court conducted a reasonably thorough inquiry but didn't give the counsel an opportunity to participate, that too would violate the rule. And that's also what we have here. So I think either ground is a sufficient basis to overturn the Third Department's 270.35 ruling in the case. And again, I'd stress that, I understand my opponent to be suggesting, or the third department certainly did, that what the court did was reasonable under the circumstances. That simply isn't correct, both as a matter of common sense and as a matter of what New York courts do every day in this kind of situation. Courts, frankly, we canvass quite a few cases in our papers. Courts routinely, this is the age of the cell phone. They make a call to determine if the juror really can't be reached. They at least, frankly, in cases that involve far more obvious disabilities than this one, somebody has to go to, so the juror herself falls ill and goes to the hospital. Even in those situations, the court makes some effort to ascertain whether or not the juror truly needs to be absent. And here, no record was created whatsoever because the court came in and simply said, this juror is not here, or so I'm told this juror can't be here, end of story.
Can we move on to the first point and the Handy analysis?
Yes, Your Honor. So going to the curative instruction issue, what we have here was a situation in which intent and intoxication were the central substantive issues at this trial.
We came to know that at the trial or at some point prior to the trial, but given the circumstances and how they developed at the scene, how would the police know that at the time that when the request was made for the BAC test?
So there's a couple of things going on here, but what they amount to is really a perfect storm in terms of the circumstances. It's not just that the police could smell alcohol on Mr. Lang's breath when they picked him up, although that's certainly part of it. It's not just that the police took him into custody and were the only ones capable of giving a blood alcohol test, which of course is a dissipating substance and time matters, time is of the essence, but also that the defense counsel asked the police to take that test. They didn't for nearly 5 hours more. And then at trial, the prosecution made it a centerpiece of their presentation and cross-examination.
Can I interrupt you
that
here
there was
for-
really
can I-
that
for a
our
second.
intoxication evidence
Counselor?
isn't. Yes,
Counselor?
please.
Yes. Slow down. Sometimes it's clumsy, the communication. I apologize for that. The key distinction for me here is between obtaining evidence and destroying evidence. And I think that's where you really need to focus your argument, because the way I understand Handy, I was on the case in the 4th Department, is that case involved destruction of evidence. Here we have a request to obtain evidence that wasn't acted upon.
Thank you, Your Honor. And I think this is important. So under this court's possession case law, I think these are the key factors. They had Mr. Lang, they had him in their exclusive control, and there was a request to take the blood alcohol test, which the police did not do in a way that was timely enough, such that then at trial, as I've said, the prosecution made a big deal of there not being an earlier test.
So
the police had Mr. Lang in every sense of the word. He was under
Counselor?
their exclusive control, and there was a request made by counsel to capture something that would otherwise dissipate absent
Counselor,
further action.
What was the evidence? It sounds like you're saying that the defendant was essentially the evidence from which they could extract this additional evidence. And I'm just having trouble understanding what evidence was in existence at the time that this test was requested that they destroyed by not giving the test. So,
as you say, Your Honor, the police had Mr. Lang. They obviously also had his blood, which contained the record or the blood alcohol level that was material to the case. But if I may, there's another line of this court's authority I think that is useful to understand here, because even when Well, as we say in our papers, we're not asking the court to overturn its standard rule, which says that the police don't need to go out and affirmatively gather evidence in the general case. However, this court has also been very careful to say that even when the police don't possess in some sense the evidence, a due process problem nevertheless would arise, or at least it is relevant for due process and Brady considerations.
Well, counsel, that's interesting. That's interesting that you raise that, because wouldn't this conduct then been better addressed in a motion to dismiss the indictment rather than a curative instruction at the back end? If you're alleging that, the police had him in custody, they made a request for the police to have his blood drawn. They dragged that out. And now at trial, the prosecutor wants to exploit that situation. To my mind, I'm thinking, well, this is a motion to dismiss alleging due process violations, and there could have been a hearing to determine that, not a curative instruction at the back end.
Well, I'd have to check the record to see precisely whether or not there was a lot of pretrial motion practice in this case. But, I think the key point for this argument is that a court has many tools to deal with a violation, and a curative instruction is one of them. If that is a lesser remedy, it's still an appropriate remedy. And I'd point the court to this, to its decision in the Hardeen case, which my friend does not mention in her briefing, but we talk about quite a bit. That's a case in which the prosecution did not gather DNA evidence in a case involving charges of rape. The court held that there was no violation because, and it emphasized this, the defendant had a reasonable opportunity to get the DNA himself. And on those facts, there was no reason to think the DNA was actually going to be material. The court, I submit to you, the court carved out those factors for a reason. It matters for the analysis whether or not Mr. Lang and his defense counsel had a reasonable opportunity to get the evidence that they asked the police to preserve and measure. They did not in this case. And it was the same in the Alvarez case, which actually involves breathalyzers and DUI. And there the court again emphasized, it didn't have to, but it said it was important that under the law that pertained to that particular kind of violation, the defense had a right to obtain its own breathalyzer analysis of the blood alcohol level.
So counsel, oh, thank you. I'm glad you could hear me. So I just want to clarify your argument. So the police did eventually administer the test. Or there
That's
was
correct.
eventually a blood alcohol test taken, correct?
Yes.
So the real argument is the timing, that they waited a particular period of time, and as a consequence, the evidence is just not as
Counselor,
valuable.
if I may.
That under the law that pertains to that.
What happened there? Correct? I'm sorry, I heard some back. What am I hearing?
Yes, I'm sorry. I'm hearing a little bit of myself, I think. But yes, the timing is important, Judge Rivera, yes.
Okay, I'm sorry, we have to fix, there's some feedback here. Hold on a second. Okay, we're good, thank you, all right. So the question is the timing. So now, let's say we agree with somewhat with your analysis. What would be the rule? So at what point is it that the judge has to give that curative instruction? So how much time has to have passed where the evidence is no longer as helpful, let me put it that way, to the defense?
The rule we are asking for is, in that situation where there's a delay after exclusive custody and a request by the defense, at a minimum, the minimal rule that we are asking for is, if the prosecution then exploits the delay in the testing as a way to establish its own intent case and say just what the prosecutor did here, that the test was unreliable, that you will never know, all those kinds of things, that's when a curative instruction is warranted.
Thank you, counsel. Counsel?
Yeah. If I may, I know I'm...
Thank you, counsel. You'll have your rebuttal time.
But I will just say very quickly on the summation point, because I think it ties in quite well with the curative instruction point. As I started, I think, on this point, intoxication was the key to this case. Whether the 70-year-old David Lang was too intoxicated to form the requisite intent or whether he was not. In the prosecution's closing, in the people's closing, they hit this point not just by pointing to the evidence in the case, which, as I said, was diminished in an improper way due to the failure to have a test without a curative instruction, but the prosecutor himself said, I don't believe he was intoxicated. Those were not accidental words. They went to the key factual issue in the case, and they had the prosecutor cloaking himself or cloaked in the majesty of the law, telling the jury what the supposed truth was. This court's cases are quite clear. I point the court to People v. Bailey as my primary authority, that the prosecution can't be an unsworn witness to an issue. That's exactly what we had here, and it was highly material given the nature of this case.
Thank you,
And with that,
counsel.
I'll reserve
Thank
my
you,
time for
counsel.
rebuttal.
Ms. Bowen?
Hi, yes, may it please the court, Michelle Bowen for respondent. As far as the request for a curative instruction goes, we believe that it was properly denied by the trial court. There's much talk about this request for BAC that came later. The court must remember that in a murder case, evidence of intoxication is not necessary to the prosecution, and the police are not required to obtain that evidence. And when, just to skip a little to appellant's point, this was not drawn out and delayed for destruction of evidence purposes. You have to understand this was a murder investigation. And so by the time evidence was talked
Ms.
about,
Bowen, I don't know if you can hear me.
BAC that came later.
Ms. Bowen, I don't know if you can hear me. It's Judge Feinman.
I can.
My question is, would you agree that if we were to reverse on the trial issue, on the juror substitution issue, that everything about Handy becomes an invite?
I would agree that if the court so chooses to take that action, then we would probably not reach the other issues. And so if we want to get to that now with the substitution of the juror,
Well, counsel, before you move on to that,
did
if I
not
can...
make a thorough inquiry because a phone call came in that, can you hear me?
Yes, but counsel, before you move on to that issue, I had one question on the blood alcohol issue. To me, it seems that I can't tell from the record whether the delay was reasonable or unreasonable, if you want to call it a delay, because the request was to take blood. The inference that I would make from the record is the police in this little town didn't have the ability themselves to take blood because they ended up taking him to a hospital. I don't know how far that hospital is, the moment the request is made, there's maybe 4.5 hours that lapse between the time the request is made and the time the blood's taken. But I don't know whether that's reasonable or not reasonable. I don't know what circumstances the police are operating under and where the hospital is.
So the hospital is a little bit of distance from the barracks where he was taken to be processed. But in the interim, as I just need to reiterate, this is a small community, this is a murder case. Evidence had to be processed. They absolutely had no ability to draw his blood at that substation. And so before they took him to the hospital, he had evidence on his body as far as the clothing he was wearing. They're not going to take him to a hospital and contaminate all of that evidence. And while the request came in, he had to be interviewed, the evidence processed. They went and they got a search warrant for items of evidence, including his blood. And once all of that was handled, they took him to get a blood draw. I would also like to note, I believe it's mischaracterized that the people used any of this information in our case in chief. We did not. The majority of this information about the blood came in response to cross-examination by defense counsel. And when they put forth a witness, an expert witness, to talk about the level of intoxication, my colleagues certainly raised issues and tried to derail that, yes, this was all speculative now. Not because the police delayed getting the blood, but because there wasn't enough information about what he ate and all of the details that would make a better extrapolation. Any information that came out at trial about the level of intoxication was merely my colleagues trying to refute the defense that was put forth. And as a matter of fact, the 911 call, which we put in, clearly indicated that he was not intoxicated to the point where he could not be responsible for his actions. He talked about how he shot his brother, said his brother's name. It's almost comical that he says his name was Russell, that he knew that his brother could be dead. He told them where the weapons were located. He gave them so much information. He said, yes, I drink every goddamn day. Why are you asking? And further to show his intent, they were concerned about where the weapon was, and he said, don't worry, I'm not going to shoot anybody else.
Ms.
And
Bowen,
so-
Bowen, let's move to the juror discharge issue. And my question to you is, how much effort would it have taken to determine the reason that the juror wasn't present?
Well, so there's a couple of issues there. Apparently, there was some night before information that this juror had to take, I believe it was a child, to an emergency appointment in Rochester. Now, I know it's very difficult for folks to imagine in Albany, but we have dead zones here in the North Country. So once that juror said, I'm on my way to Rochester, there's a significant amount of time, it's something that's trying to be fixed up here, where it's a dead zone and you have no cell service.
But there's no indication that there was an attempt to call. There's nothing on the record about that. So that's just pure, it seems to me, speculation about what may have happened. Isn't it necessary for the court to make a record of what attempts were made to contact this juror and determine her availability?
I believe when the court came out and said that the juror called and said she would not be here today, that he had to replace her, and then he asked if there was any objection. In the record, you can see where it's ... to indicate he held it a moment to see if there was any objection, and he said, in any case, let's go on and call our next witnesses. There was no objection. I would just like to set the scene for the court here. This was a defense table that constituted 4 attorneys and assistants, 2 law firms, that had been a contentious trial with many objections. And at this key juncture, they don't raise an objection. And so I would just say that the judge put on the record the information that he had, which is she called in today. She said she wasn't going to be here. Is, you know, if there's any objection, ... waited, there was no objection. And this really all occurs later when the judge...
Counsel?
Yes.
I thought the court indicated that objections would be heard later. And in fact, when the objections are discussed, the courts said to defense counsel, you seem to disagree with my approach. Is there something you wish to say? So obviously the court was aware that there was a problem from defense counsel's view.
Well, I believe that he said we
Counselor, this is Judge Feiman again. Counselor, I don't know if you can hear me. I hope so. And I don't understand what the defense was supposed to object to because it was already a fait accompli, wasn't it?
I think the defense could have raised the issues that we're discussing here today, which is what efforts were made. Can the court just articulate to us so that we know what happened? The judge did at the conference when he said, I noticed your body language, that there was an issue. And then defense counsel articulated all the things he could have put on the record at the time when he was asked for an objection. I would also like to say that the judge had said, well, we can discuss this later because it was a medical appointment issue. But then after he said that, he said, are there any objections? So he said one thing first and then the other thing after, and then waited a bit to see if there would be any objection, and none was raised, so he moved on.
You know, Judge Fahey, my understanding of the record is a little bit different than you had articulated. I understood that the juror told the court attendant 2 days earlier that she had had a medical appointment and that she went forward with that, but no attempt was made to contact the juror or to clarify if that was true by the court. Honestly, I don't know if the court had been notified by the court attendant or not, but that was my understanding of the record.
I believe that there were two conversations. It sounds like at one point they thought that there was this issue where they thought it was raised during voir dire. That turned out not to have been correct. And then there was some discussion that she had let somebody know a period of time before. I believe the final in the record is that she called the night before to say that she wasn't going to be here today, and then she in fact did not show up.
Thank you.
And so I just want to move on to the issue of my colleague's summations. I just want to say that they were a fair response to defense counsel's summation. In that summation, defense counsel called law enforcement slipshod and incompetent. They're not trustworthy. They wouldn't look you in the eye, he told the jurors, and that is indicative of people who lie. He told them at the end, you cannot believe Trooper Bogart or Peters, but the fact that the Trooper Bogart and Peters are unreliable, untrustworthy, proves the evidence is insufficient. Now, he didn't say I think or I believe. He just straight up usurped their role as a fact finder and said, these are unreliable liars. And so my colleague perhaps should not have used words like I, but I think it was a fair response to defense counsel's completely trying to obliterate the work that law enforcement had done. And so I believe it absolutely was a fair response to that summation, which was just littered and peppered with calling law enforcement.
So, counsel, if I can just clarify, so your position is, if defense counsel gets up and says something to the effect, those witnesses are liars, that the prosecutor can get up and say, I don't believe the witnesses are liars?
I don't believe he got up and said that the witnesses are liars.
No, just my question.
Yeah,
No, I'm asking you, my question. Can a prosecutor then get up and say, I don't believe the witnesses are liars? In my opinion, those witnesses are not liars.
I believe he can, in a sense, dress that up. I mean, I don't think he should say those kinds of things, but I think that because the summation was so direct in that aspect.
Doesn't our case law say that you cannot get up, as a prosecutor, get up and give your opinion, your assessment?
I believe it depends on what the summation was of defense counsel. Perhaps there should have been objections at the points where defense counsel was having such an improper summation.
Thank you, Ms. Bowen. Mr. Hellman, your 2 minutes.
Yes, thank you, Your Honor. 3 quick points. Starting with the juror issue, the court is absolutely correct that all we can do is speculate as to whether or not juror number 9 could have changed that appointment, could have had somebody else go to it, because the court made no effort whatsoever. And Judge Fahey's account of the chronology is correct, by the way, during the apparently 2 days in which they had notice of this. Instead, it was already a fait accompli, as you said, Your Honor. The juror was substituted, and if Rule 270.35 is going to mean anything, that cannot be a reasonably thorough inquiry. The second point on the adverse instruction, just to respond to what my friend on the other side is saying, I just want to be clear. The testimony at pages 853 forward shows that the police were perfectly capable of taking a breathalyzer from the moment that they had apprehended Mr. Lang. They did not do that. So there were ample ways to measure Mr. Lang's blood alcohol content. It is not correct to say that they had to wait until 9 o'clock to do it, and certainly not more than or approximately 5 hours after our request for doing so. And then third, I just want to end, I guess, where I ended my opening remarks. This was all about intent. It was all about intoxication. This was a close case involving a 70-year-old man who called 911 and admitted that he had been drinking, that he had shot his brother. This comes down to whether or not to blood alcohol levels and intoxication.
Counsel,
It was not a,
Counsel, I'm sorry to interrupt your last point there, but I just want to circle back, now that you've said that, to something that was mentioned earlier. So if the court were to agree with you on the 270 issue, on the juror discharge issue, I think you said, no, we would not have to reach the question of the adverse instruction. But isn't this issue just going to come up again, the issue about the police not responding and preserving, what you've called preserving the evidence? Isn't that going to come up in a retrial?
Yeah, I appreciate you raising that question, Judge Rivera, because I had the same thought as I was sitting here listening to the counsel's argument. Yeah, I have a two-part submission. The juror issue is sufficient by itself to require vacature, but the issue of curative instruction, I think, would be best reached by this court as well, both as guidance for the courts of New York and for this case, in terms of what the proper way to proceed is, given the failure to take the test on the facts that we have here. So the juror issue is sufficient all by itself to vacate the verdict here, but it would be prudent and I think appropriate for the court to reach the curative instruction issue as well, given its importance to the case.
Counsel, just a quick follow-up on that. It seems to me if we were to reverse on the substitution, and I think this follows up on what I believe Judge Wilson was getting at earlier, isn't the entitlement to a charge
So why
based
doesn't that become, Counsel, this is Feynman. I hope you can hear me. I don't understand why that doesn't become an advisory opinion, because the record could be different. You don't know what that trial judge on retrial, it may not even be the same judge, is going to do with these issues.
I appreciate it. I know there's two questions coming at once. To Judge Feynman, what I would say is I appreciate the advisory aspect. I think if the people agreed that they would not, make an issue of the delay in the testing at any retrial, then, but I don't know if the people would be willing to make that concession here.
But counsel,
so I think in that sense, it's not advisory if it comes up again. We're going to have the same problem of a delayed test. But and then, I'm sorry, there was another question.
Yeah,
Yes.
it actually is the same question, but the point not being what are they going to concede or not, the point being I think that at the next trial, the circumstances may be different, the record developed may be very different. As I was starting to say, I think Judge Wilson was asking about the development of the record. What time did this get in? We have, but who did it go to? Where did it go? What were the opportunities? Is the delay reasonable? All under these circumstances, all of that may well be different and more fully developed in the next trial. What type of guidance would we be giving then in doing that under these circumstances where, again, assuming we would reverse on the first issue?
So I'm just thinking it through, Your Honor. I think to the extent that this decision vacates the third department's opinion, which says that it was appropriate not to give a curative instruction, then that would obviate the need necessarily to deal with the adverse instruction issue. To the extent that decision remains good law in the third department, I do think there is some benefit to the court reaching the issue because that would then become the operative precedent in any retrial of Mr. Lang.
Thank you, Mr. Hellman. Thank you,
Your Honor.